So Judge Aileen Cannon is trying to decide whether Trump improperly had all these documents and improperly stored the documents and then didn't give the documents back. But the question is, did he have documents he shouldn't have had down at Mar-a-Lago? And Trump has said all along, I'm covered by the Presidential Records Act. And you know who else said that? Mike Davis on our show like 2 summers ago, Mike. You came on, this is when we first met you. And you made the strong case like he can do everything he did. He doesn't have to make special designations. He was entitled to have all these documents and he didn't have to do anything special. And that's an affirmative defense to all of these charges. Well, Trump's lawyers have just proposed Mike's exact argument in their proposed jury instructions before the judge. And rather than saying, as so many on the left did when they heard this argument from Mike and others, that's absurd, that's not what we're going to put in a jury instruction, she did it. So she said to the lawyers, I want you to write me up jury instructions based on the following 2 alternative premises. One is the Mike Davis argument that Trump was allowed to have it all. He didn't have to make any special designations. And that's kind of an affirmative defense to all these charges against him. And that would be one jury instruction, which would totally get Trump off entirely. And Jack Smith himself concedes that in his papers, saying, basically, what the hell are you doing? What are you saying? If that's the jury instruction, the case is over. So what are we doing here? The other instruction is a little bit better for Jack Smith, but it's still not good for him. It's still not what he wants. He didn't get any proposed jury instruction requirements that he wanted. The other one is, okay, jury, you can look at whether a record retained by a former president, whether the government has proven beyond a reasonable doubt that that record is either personal or presidential. And the follow-up would be, if it's presidential, he shouldn't have had it. If it's a personal record under the Presidential Records Act, he was allowed to have it. Now, keep in mind, Jack Smith is saying the Presidential Records Act doesn't apply at all here. I don't want to see the Presidential Records Act mentioned in jury instructions to the jury in this case at all. It doesn't belong. And the reason he says it doesn't belong is because he's charging Trump under the espionage statute. And he says, you don't get to say I had highly classified CIA briefings and I was allowed to keep them forever as a personal document under the Presidential Records Act. That the Presidential Records Act is supposed to just say, hey, if you made personal notes while you were in the presidency that you want to take with you when you leave, okay, you can do it. That's what Jack Smith is arguing. Like, why are we even talking about presidential records? That's not a defense to espionage and taking documents that are highly classified. And both of her proposed jury instructions that she wants them to give her like specific language on assume, number one, that the Presidential Records Act does apply in this case. Jack Smith's mad. And in one instance, that therefore the jury has to decide just personal or professional, 50-50. And if they go with personal, Trump wins. And the second one is, as I said at the top, that under the Presidential Records Act, it's ball game. The president can do whatever the hell he wants. He can take whatever the hell he wants. No special designations, the Mike Davis argument. Do I have my facts generally correct? I'll start with you today, Dave. Good to see you.
Great to be back with you, Megyn. And Mike, you've got it right. And that's why Jack Smith was so upset, because the law says that the Espionage Act is the Espionage Act and obstruction is obstruction. And there's nothing in the law that says the PRA, which was a law that was enacted after the Nixon administration, is allowed to override that. You quoted the PRA correctly. And what Judge Cannon came up with were 2 scenarios that were completely erroneous. And that's why Jack Smith had a conniption about it. In fact, I would love to see what he did behind the scenes. If you saw what he did in his pleadings, this is a mild-mannered guy normally. And so he's saying to the judge, you're wrong about this. And if you don't change your interpretation right now, then we're going to go to the 11th Circuit and get you reversed. And then there's the threat of getting her removed from the case. So I do believe that this is a real, an understandable concern for Jack Smith, and he will push that nuclear button if necessary.
So normally you couldn't take such a case up on immediate appeal where she ruled, this is the standard of law, or this is what I'm going to do in a jury instruction. But he argues in this, you can, when your proposed jury instruction as a judge, it completely eliminates the prosecution's chances at getting a conviction. He says that.
Right.
Go ahead, Dave.
Right.
I'll let you finish.
Yeah, Megyn, absolutely right. Here's the issue. What Judge Cannon did was not a final order. So you can't really appeal it yet. And so that's why Jack Smith is not appealing what she did. What Judge Cannon said is, I want you parties to engage in the following. So it's not really a direct, specific order. And that's why Jack Smith is saying, hey, be specific. And if you want to dismiss this case, then do it, because then we can appeal you. But if you wait and you adopt this later on, or you dismiss the case during trial, then we're screwed. Then we cannot appeal it because double jeopardy attaches once a jury has been seated. So either dismiss this case now, or make it specific that these are the jury instructions you are going to use. Don't use these weasel words of engaged that prevents us from appealing, because we are ready to appeal unless you change your ways.
Mike, kudos to you in driving the main defense, which now has persuaded this judge, at least in part. You've called this, really, I remember this because we were all kind of confused about the Presidential Records Act, and you came out swinging. I didn't know you. I was like, who is this guy? He's brilliant. Listen to this argument. We had you on. You spelled it all out. People mocked you. They're, oh, who's that? Here it is. It is his defense, and this judge has bought it, at least in part, because Presidential Records Act is both in number 1 and number 2. And number 2 is the Mike Davis defense entirely, which has got Jack Smith spitting mad today.
Well, I mean, I people say that I'm crazy, but I tend to be right. And I would say this, that I didn't make up this legal theory. This was a 2012 decision by an Obama judge, Judge Amy Berman Jackson, when President Clinton had 8 years, 79 tapes of audio recordings in his sock drawer. And these audio recordings were recorded by the White House Deputy Chief of Staff for Operations. So they're definitely White House records. And they were recordings of President Clinton's conversations with his national security officials, his foreign leaders, many other highly classified, born classified, the most classified secrets imaginable, the thought process of the president on national security matters. And when Tom Fitton at Judicial Watch sued for these records, that's where we got the Clinton Sartre case in 2012, that this judge said that it is there are presidential records that belong to the government, but the president can access them anytime he wants. He can have his records anytime he wants, even if the government owns them, or they could be personal records. And the mere fact that President Clinton took these highly classified recordings out of the White House with him and did not turn them over to the archives when he left office, deemed them personal under the Presidential Records Act. You may not like that ruling. You may think that ruling is incorrect, but that is the ruling of that 2012 judge, and Judge Cannon is following that precedent.
Just on the question of whether he can appeal her immediately, Dave, he writes the following in his brief. It is vitally important that the court promptly decide whether the unstated legal premise underlying this recent order does, in the court's view, represent a correct formulation of the law. If the court wrongly concludes that it does, and that it intends to include the PRA, Presidential Records Act, in the jury instructions regarding what's authorized under Section 793, which is the Espionage Act, it must inform the parties of that decision well in advance of trial. The government must have the opportunity to consider appellate review well before jeopardy attaches, which is when you swear in the jury. Then he cites 2 cases for the following premises: the adoption of a clearly erroneous jury instruction that entails a high probability of failure of a prosecution, a failure the government could not then seek to remedy by appeal or otherwise, constitutes the kind of extraordinary situation in which we are empowered to issue the writ of mandamus. That was citing to an appellate court, and then a similar finding in another appellate court case from a different jurisdiction. So he's saying, if you're going to stand by this, and these are the 2 proposed jury instructions we're having to choose between, I'm going to mandamus you. I'm taking it up to the 11th Circuit Court of Appeals, and I'm going to have your bosses slap your hand and get this taken care of right away. But the problem, Dave, if he does that, if Aileen does this, and then Jack Smith does the mandamus, it's more delay, which works for Trump.
Agreed. But if you come at it from my perspective, which was this case was never going to go to trial before the election, then I think Jack Smith has no choice. I think, knowing that this case was always going to be pushed back, this case has been slow walked from the beginning, that he's got to go to the 11th Circuit, but he can't do it yet. This is the frustration for Jack Smith. It's not just that he sees this as an erroneous interpretation of the law, but it's that he's not able to appeal it yet because Judge Cannon is saying, let's just engage. This is not a final order. These aren't the jury instructions. And number one, you don't do jury instructions this far out. There's not even a trial date set. I've never seen jury instructions being proposed this far out. And number two, if you're going to give jury instructions, do it. Then Jack Smith can appeal it. But if she continues down this road and says, let's discuss it, and then issues her final jury instructions in the middle of trial, which is what normally happens, then Jack Smith is done because he cannot appeal it. It's over. Double jeopardy attaches. And he sees this case slipping away if that happens. That's why he got so hot under the collar.
With cyber attacks on the rise, protecting your data security is more important than ever. So why is Congress considering a bill that could put your credit card data at greater risk of being hacked and exposed to foreign networks? Our advertiser, the Electronic Payments Coalition, says the Durbin-Marshall credit card bill shifts billions in consumer spending to less secure payment networks, also that corporate megastores can make bigger profits. Find out more about the issue at electronicpaymentscoalition.org and decide for yourself if you would like to tell your senators to oppose the Durbin-Marshall credit card bill. Hey, thanks so much for watching. If you like what you just saw, hit the subscribe button for more clips and full episodes.